All right, everyone, we are back. Make sure your camera's on, please. Jeffrey, what is your camera pointing at? Is that chargers? All right, so we got Vanessa, Franciele, Erica, Robin, Miguel somewhere, don't know where, Jeffrey. Oh, there you go, there he is. Fabiola, Stephanie M, Nurika, Chris, Ingrid, David, Muslima, Yvette, Pedro Arelis, Elena, Di Stefani, and Verona. All right, got everybody. So, we have a couple of chapters on contract, okay? And this is not a long chapter, so we're going to be done on time, but it is a very important chapter. This is going to be the fundamentals, so the essentials of contract law. It doesn't have to specifically adapt to or be part of, be concerning real estate only. It's contracts in general. We have another chapter, which is contracts for real estate. Okay, and then we have the state portion. So when we get to the final week, we're going to talk about New Jersey or whatever state we're handling at the time. And we're going to talk about the actual state law towards contracts. Okay. So real estate contracts are legal agreements. Sorry. So real estate contracts are legal agreements that underlie the transfer and financing of real estate, as well as the real estate brokerage business. Sale and lease contracts and option agreements are used to transfer real estate interests from one party to another. And mortgage contracts and promissory notes agreements are part of financing real estate. Now, listing and representation contracts establish client relationship and provide compensation. So there's different documents in a real estate transaction. Again, there's a financing, there's a purchase, and then there's a representation of a client. So all independent documents. In order to work with real estate contracts, it is imperative to grasp the basic concepts that apply to all contracts in general. And these concepts provide a foundation for understanding the specifics of particular types of real estate contract. So things that we need to remember that are very important is that not all contracts are valid, not all contracts are enforceable. There are certain standards that must come with a contract in order to make it a valid enforceable contract, okay? So that being said, a contract is an agreement between two or more parties who, in the meeting of the minds, have pledged to perform or refrain from performing some act. So a contract is an agreement. You're not going to agree with yourself. Well, you might, I'm not sure. But you're not going to agree with yourself and say, hey, I allow myself to do this or whatever it is. I would consult a doctor at this point. But if you do, right, this is how it works. It has to be between two different parties or more, right? And establish a meeting of the minds. That means our two minds are in agreement. They're in unison, right? Laura just said meeting of the minds. Yep. So our two minds are in agreement. And a valid contract is the one that is legally enforceable by virtue of meeting certain requirements of contract law. If a contract does not meet the requirements, then it's not valid. It could be a void contract, okay? So you cannot take them to court. Now, note that a contract is not a legal form or a prescribed set of words in a document, but rather an intangible agreement that was made in the meeting of the minds of the parties of the contract. Again, when we met in agreement. It doesn't mean we need to meet face to face. It's when I saw your offer, I read your offer, I agreed to your offer. That means I'm meeting, my mind meets with yours when it comes to this purpose, whatever the purpose might be. So in terms of validity and enforceability, a court may construe the legal status of a contract in one of four ways. It could be valid but unenforceable. It could be void or voidable. Okay? So a valid contract obviously meets all the legal requirements, okay, for the validity. We're going to go over these in a little bit. A valid contract that is in writing is enforceable with a statutory time period. A valid contract that is made orally generally is also enforceable within a statutory period, with the exceptions noted below. A valid but unenforceable, right? State laws declare that some contracts are enforceable only if they are in writing. So it doesn't mean it's not valid. It's just that if you want to take me to court, it must be in writing. Okay? So these laws apply in particular to the transfer of interest in real estate. Thus, while an oral contract may meet the tests of validity, if it falls under the laws regarding a written contract, the parties will not have a legal recourse to enforce performance. Can't take me to court. An oral long-term lease and oral real estate sales contract are examples of contracts that may be valid but not enforceable. So what we're saying here is every state has their rule regarding what's enforceable or not. For instance, in the state of New Jersey, if it's a lease for more than 3 years, it must be in writing. We're not saying that it's not valid, right? But it might not be enforceable. You see what I'm saying? And a contract for the transfer of real estate, so for the sale of real estate in New Jersey, has to be in writing. Other states might have different rules, but for transfer of real estate, traditionally, it has to be in writing. Meaning for the sale of real estate, it must be in writing. Can we have a 1-year lease and not be in writing? The answer is yes. Depending on state law, not a problem. Is it valid? Yeah. Is it enforceable? Might not be. Because how are we going to prove the terms of that contract? You guys understand what I'm trying to say? So valid, but maybe not enforceable. Also, you will say later on, but also a contract that was done by people that are not in the right state of mind, but when they sober up, for instance, let's say they were drinking or under the influence, when they sober up, right, they're now in the right state of mind, and if they choose to proceed where it was valid and unenforceable, now it becomes enforceable. You guys understand? So there are conditions to the enforceability of a contract. And Laura, yep, there you go. She's answering everything right. Cool. Now, a void contract, if a valid contract contains all the elements to be valid, right, then a void contract does not meet the tests of validity. It doesn't contain all the elements. Okay, so there's something missing. For instance, a contract that does not include consideration, right, and you guys should know consideration by now, money or exchange of value, right? So if it doesn't include an exchange, then it's void. Because if I sell you something and I don't get paid for it, right, then there's no consideration. If you give me money and I don't give you anything in exchange, so I don't provide the service, or I don't sell you the house or transfer the house, then it's a void contract. Give me my money back. Okay. Then we have voidable. Voidable is very similar to unenforceable, meaning it appears to be valid, right? It appears to be valid, but it's subject to rescission. What is rescission? Cancellation by one of the parties. So rescission, every time you see the word to rescind, is to give up or cancel on it. Okay? So to rescind is to give up or cancel. And one example, again, is somebody that was a victim of duress, coercion, or at the time of creation of the contract, or minors. Minors might be able to get into a contract, but once they reach the age where they're considered legal adults, they can cancel that contract. They can void the contract. You guys understand? It's valid, right? It's valid until one of the parties that has the right to, until one of the parties says, I don't want to move forward with this. Simple as that. So it's a voidable contract. Very similar to unenforceable. Okay? Now, right here, a voidable contract differs from a void contract is that the latter does not require an act of disaffirmation to render it unenforceable. Right? So I don't have to actually cancel it or put a statement to it. Yep. Laura keeps on answering. Good, good. There you go. So, validity of a contract. Okay, very important. These go together. Right here. These go together. You have to be a competent party. What is a competent party? We're going to go over that in a second. It's somebody that's over the age of 18 and of sound mind. Sound mind is very important because right here, what you're doing is out of your own voluntary will. You want to enter into this contract, right? If you're under 18, right, you might not understand the terms of the contract. So they don't consider you doing something out of goodwill or good faith or understanding. So competent parties and voluntary, they go together. Mutual consent. It's the meeting of the minds. As we agree to all the terms of the contract. I'm offering it to you, and if you accept, boom, mutual consent, meeting of the minds. Valuable consideration, the money. Okay? Again, money. And if it's not money, then it's something equivalent. Like, hey, realtors, you can sell my house and I'll give you the car that's in the garage in exchange. It's worth more or less whatever the commission is. Instead of me giving you cash, boom, there's a car. So it's called legal tender, exchange of value, money, right? Or even love and affection. I think we mentioned this earlier as well last week. Love and affection. If I give a property to my son, I don't expect him to pay me. I expect him to, that this exchange is based on love and affection, right? And then most important of all, because you can have all of these, but if the purpose or the object of this contract or the reason for this contract is an illegal reason, something that goes against public policy, right? Then the contract is void. So I'm selling you, right, as an example. I'm sorry, I'm asking you, I'll give you $1 million if you sell Coke. Guys, is this a valid contract or is it a void contract? I'm giving you $1 million to sell Coke. Is it a valid contract or a void contract? Let me know in the chat. Nurika, you don't have to yell at me, okay? Laura, you got it. Miguel, you got it. Oh, there you go. Somebody, finally, right here. I don't know what you guys been thinking with all these voids right here. I'm sure you're thinking about something else. Because I meant Coca-Cola. I don't know what goes through your minds or what kind of day and age we're in that everybody thought about something else. Robin says, I was just going to mention Coca-Cola. Exactly. Laura says, I'm drinking one now. There you go. If it's Coca-Cola, it's enforceable, yes. But that's the distinction right there. Depending on the type of Coke, it's either a void contract because it's unenforceable, it's the legal purpose is not there, it goes against public policy, or if it's Coca-Cola, right, then it's a valid contract. As long as there's mutual, let me go back to this, As long as there's we're competent parties, we understand that it's Coca-Cola, right? And we agree to exchange the services of the sale of Coca-Cola for $1 million in payout, right? That's a valid consideration. And it's the right type of Coke, so there's legal purpose. Therefore, this contract is good. You got it? So very, very important. Sorry, I have to do this. 1, 2, 3, 4, 5, 7, 8, 9, 10, 11 out of the 20 students, 11 out of the 20 were thinking about the wrong type of Coke. Wow. Anyway, so back to this. Competent parties. What does it mean to be competent? It's 2020. Anything can happen nowadays, right? The parties must have the capacity to contract, and there must be at least 2 such parties, obviously. Thus, the owner of a tenancy for life cannot deed his interest to himself in the form of a fee simple, as it would involve only one party. Capacity to contract is determined by 3 factors: legal age, mental competency, and legitimate authority. And depending on state law, a contract involving a minor, as I said, may either be void or voidable. So if you enter into a contract, you're 15 years old, can you enter into the contract? If you're 15 years old. Let me know. Can you enter into a contract if you're 15 years old? That's a state exam question right there. You're 15 years old, you enter into a contract of sale. The minor later on cancels the contract. Says, nope, not selling. Is it enforceable? The answer is no, it's not enforceable. But it depends on the state. Yes, because we're talking about the exam in the state of New Jersey as an example. It's not enforceable. It's if the minor decides to void by the time the minor reaches of age, right? Then the other party cannot sue. It was a voidable contract. Very good. So not enforceable. Nope. Very good. Mutual consent, guys, we already covered this. Valuable consideration, we already covered this as well. In some states, it must actually state the actual purchase price in the contract. Okay, so if it's sold for $200,000, the contract must state $200,000. Okay, how do we figure out consideration? Valuable, exchange, good consideration, love and affection, then sufficient or insufficient. If it's sufficient, means it covers the whole thing, is valid. If it's insufficient, it might not be valid. We already talked about legal purpose. That was the Coke example. Voluntary or good faith act, that means you want to. You're not under duress, you're not under coercion, there's no fraud. You understand all the terms of the contract. Misrepresentation, we're going to talk a lot about this in different chapter. But misrepresentation is when you say there's no issues with the house, when the house is falling apart. All right, sometimes we look at the house, the seller knows that there's issues, there's leaks, right? There's mold, there's stuff that maybe you cover, right? Or you only show the property on certain days so it's not as visible, right? And the seller is selling with a pretext that it's no issues. There's no issues with the property. If I put an offer on a property that I think there's no issues, is that fair to me? Or should I know all the issues with the property? So I'll answer that in a second. So if there's misrepresentation, like if I was not aware of all the circumstances, how is this act voluntary or a good faith act? How did I purchase this voluntarily, right? I did not understand the terms. Somebody pretty much committed fraud against me, okay? So it says right here, right? If the property seller induces a buyer to purchase a house based on assurance that the roof is new, the buyer may rescind the agreement if the roof turns out to be 20 years old and leaking. right? Now, very, very, yep, you need to know, very, very important. This is why we must bring the professionals in, the home inspector, right? Nobody should waive inspections. That's something that shouldn't happen at all. Can we advise the client, don't waive inspections? Sure. Can the client waive inspections? As long as they're voluntary, good faith act, that they want to waive inspections and they were not coerced by us, right? That's it. We're all good. It's on them. Now, Yvette is asking, how can you prove it's known? Well, technically you can't, but once you determine, for instance, let's say mold. Let's talk about mold real quick. There's a paint, you can paint over the mold and it kind of like disappears temporarily, right? It doesn't fix the problem, but it traps the mold in. Over the years, if the problem is not resolved, as you can imagine when you're patching something, if the problem is not resolved, over the years, you're going to see it again. You're going to find it. Now, the good thing about mold, or maybe the bad thing about mold, is that it's a bacteria. So you can test it and figure out how long it's been there. So if I purchased the property today, right, and then a year later, I have huge amounts of mold in the property, a basic investigation will say, well, the mold's been here for like 10 years. As an example, like this situation is not from the past year. This situation has been going on for years, depending on the amount of mold that sets in the walls. So in every state, there's different rules for this. But again, state of New Jersey, as an example, you have 6 years where you can sue the other party. So this was a year later. Do you think I can go back and sue the seller and say, hey, you either give me money or you take back the damn property? I don't want it, right? Usually we go for money, but this is the scenario. You have to be fully aware. So misrepresentation must be clear. Representation must be clear. We have to be fully aware of all the conditions of the property before buying the property. All right. Let me see here. Personal example. My friend bought a home from a family member who has tons of problems with okay, and my friend has invested a lot of money into the house. Can my friend sue the realtor for not informing my friend of all? I love how you keep on saying my friend. Of all, I know the problem. It's always a friend. I know it's you. Don't worry about it. I'm not going to tell everybody that E. Stefani Hernandez is having issues. It's always a friend. Don't worry. People on YouTube, don't feel bad for her. Just kidding. But it's funny because every good story starts with my friend, or every sob story starts with my friend. It's not for me, it's for a friend. So, first of all, first big mistake, and I hope nobody gets offended by this, but the first big mistake is you bought a home from? Yeah. Like, my phone's falling apart, but to my family, like, this is the best phone ever, right? Best phone ever, take it. All right, pay double for it, only because we're family and friends, right? By the way, I do have a good family and I have good friends, so I'm just saying, this happens a lot. But can you sue? See, the problem now, it's a matter of conscience. Are you going to sue your family member? That's the question. Can you sue? The answer is yes, absolutely, you can sue. It's known issues with the property, so it doesn't matter. See, the transaction is between two legally competent parties. It doesn't say transaction, for you to be able to sue, it cannot be family. No. No. You can sue, definitely. The realtor, the friend, right, the family member, right? You're not suing only the realtor, you're suing the family member, you're suing the home inspector. Everybody that was part of the transaction could be sued, right? But don't pin it on the realtor when I'm sure that the family member knew about all these problems. Okay, the question was, can we sue the realtor? No. Everybody. There's more to this? Okay, hold on. All right, I'm sorry. Time out. I'll be right back. Sad, isn't it? It's not even the seller, it was the realtor. All right. So here's the thing. There's good news and there's bad news, right? I had to have a crack at it, but the good news and bad news. sometimes, just like Verona was saying here, what if the realtor is not aware? Realtors, we are trained, and I'm showing you here in this course as well. We are trained to do the best for our clients, and that includes knowing as much as you can about the property as possible. If you represent the buyer, right, then you have to ask the realtor that represents the seller to provide as much information as possible. The other thing is you have to advise your clients, hey, let's do a home inspection. Let's bring the pros. Somebody needs to look at this house and figure out. Let's do the city inspection. So for the CO, right? We need to figure this out. So as a realtor, our job is to care so much for the client that the outcome, which is the financial portion, the outcome is not what matters. I prefer for you not to buy, right? For you not to buy, at least not right now, than having to deal with investing a lot of money into a house that I just helped you buy. So I'm broke, but I prefer the integrity versus making money and you're screwed later. You guys understand? This is your duty, guys. It's very important as a realtor. It's very important. You can get sued big time. And again, it does not matter if you're a friend, if you're a family member, or if you're not. You get sued regardless. We need to know, yep, Laura says everything. We need to know everything. Very, very important. Right here, Yvette says, if you have an inspection, they look at the roof and it says it's new, but good, but then you purchase and it has a leak, and you find out that the previous owner, represented inaccurately, I guess. So this is why we have to also fill out something called the seller's property condition disclosure statement. So the seller must fill out a form that says, to the best of my knowledge, this is what it is. If you find out later on, let's say a neighbor tells you, hey, did you ever fix that roof? I know the previous owner had issues. Boom. That's a witness right there that the issue was already existing, right? Is it easy to figure these things out? A professional in the field will probably tell you, right? I had somebody here in the roof to fix the leak in this building, and the owner of the building had 2 or 3 people here, and I asked a friend of mine to come over. He solved the problem in like 30 minutes, right? So it has to be a professional, somebody that actually knows what they're doing. Yeah, they'll be able to determine if the roof is 5 years old, if the roof is it was just patched or something is going on, right? I'm telling you, after 6 months of being here, this guy came in, 30 minutes, fixed the problem. 30 minutes. And with these 30 minutes, half of those 30 minutes was him talking to me here, explaining the problem. You see what I'm trying to say? So things could be fixed. It's just people always look at money as an issue first, and they forget that later on they can get sued, right? So if you purchase from somebody that knows the problem, there was misrepresentation, you can sue them. In fact, they're going to sign a document attesting that their statements are true. Okay? What, you need a guy to do the roof? Or a guy that will fix your problems in... Where's Osmani? Let me talk to your husband again. Like, what's going on? All right. All right. Hit me on the side on the WhatsApp. Let me know what the issues are. And if I have somebody, I'll let you know. Okay. Most likely, I have somebody that can help you. Osmani will be on the next one? Okay, cool. So this time you're doing one at a time? Cool. All right. Then you better pass so you can shove it in his face. See, I did it. Put pressure. All right, Yvette is typing. No? Oh, I thought you were going to ask a question. I was waiting on it. All right, if you guys ever need referrals for anything, I got an extensive list of contacts. So if you need attorneys, mortgage people, appraisers, inspectors, whatever you guys need, just send me a message and let me know, and I will give you the contacts. Okay? If I don't have for your particular problem, I'll also let you know that I don't have it. So I'm not going to be sending you stuff that you'll need. Okay. So let's go back to this. Oh, just one more thing. Sorry, just one more thing. Don't be that family member. Okay? Be the right type of family member. Care for people. Very important. You could lose your license real quick. Aha. Olga, what's up? So you had a break between classes and saw my live? Well, thank you. Thank you for joining and saying hi. You're preparing for the exam? Cool. Let me know when. This is on YouTube. Let me know when. Let's talk soon. All right, so back to this. In addition to satisfying the requirements, a contract that conveys or transfers an interest in real estate must be in writing, contain a legal description of the property. You guys already know legal descriptions, right? And be signed by one or more of the parties. If it's a lease, sometimes only the landlord must sign, or only the tenant must sign, depending. I already talked about statute of limitations. That's on a state-by-state basis. Statute of frauds requires that certain contracts, keywords right here, certain contracts. If it says certain contracts, does it mean all contracts? No. So certain contracts must be in writing. And the reason why I'm saying this is there might be a question that says all contracts must be in writing as one of the answers. And usually I have that question in my school exam, a similar question, and usually that's what people answer. Students usually go for the all contracts must be in writing. But remember, a contract could be oral, right? It could be verbal. For instance, I'll let you rent from me on a month-to-month basis, just pay me, right? So it's a verbal contract. Does it have to be in writing? How are we going to sign if it was a verbal agreement? Does that make sense? So signatures and in writing are not always required. You have to remember that. All right, we'll talk about this later. Contract creation. Let's start with offer and acceptance. Yeah, so the old book does not say certain contracts, but it says most contracts. Okay? The old book says most contracts must be in writing, or some contracts must be in writing, or it will say in certain instances of the book says not all contracts must be in writing. Okay? In fact, if you're in the contract on second or third page, it actually says, it talks about the oral or written contracts, and it says parole evidence rule and all that stuff. So it's written right there. Okay. Now, offer and acceptance. So if you're looking at the old book, go towards the end of the chapter, of that chapter, it talks about counter offers and offers and acceptance. In the beginning also talks about it. But offer and acceptance right here is when I put an offer, you accept. That's the meeting of the minds. But there's something called counter offers, and that's why I went straight to Muslima to tell you to go to the end of the book, because there's counter offers. Offer and acceptance is easy. Here are my terms. If you accept, good. We go forward. A counter offer is when I say, hey, here's ABC terms, right? And then you say, well, I like A and C, we'll take B out, and here's my D. That's a counter. If I accept it, we stop right there. If I counter with A, C, D, and hey, here's another clause to it, another suggestion, let's put it like that, A, C, D, E, right? Then it's another counter, which the other party may accept, may not accept. But counter offers are very, very important. Because counter offers, guys, it says right here, counter offer, right? By changing any keyword, any of the terms of an offer, the offeree creates a counter offer. That means that the original offer is void. Okay? At this point, the offeree becomes the offerer, and the offeree gains the right of acceptance. If accepted, the counteroffer becomes a valid contract. Now, Laura just wrote something in YouTube, which is rejection, and I always talk about this in the previous book. So, Muslima, if you're looking at it, where it says counteroffer, right below it says rejection. Why? Because let's say, as an example, these are my terms. Let me go back up. These are my terms right here. I am offering you the $200,000 you want for your house, right? But I want you to include the drapes. So this is my offer. I'm buying your house, but I really like the drapes you have, so I want you to include it. The seller says, I see your $200,000 offer. No drapes. Okay? So that's a counter. I'm telling you, I accept your $200,000 offer. You want drapes? I don't want to sell you the drapes because the drapes have been in the family for generation. My grandma gave it to me, whatever, right? So drapes are not included, but I'll accept your $200,000, right? So the moment this counter was created, this equals rejection. I rejected your offer, or the offer, just because of altering one of the terms. And what was the term? The drapes. You guys understand? So every time there's a change, even if it's something insignificant as drapes, right? And the question could say that as well. Something as ridiculous as drapes or curtains, whatever you want to say it. But something ridiculous like that will be in the state exam. The moment I altered something, it could be a letter, ABC, ACD, so there's something missing. The moment there's a change, it's a rejection. What does that mean? Well, Mr. Seller, I appreciate the opportunity, but I'm not buying your house. And I can walk away. Can the seller sue me because I rejected that counter? No. The counter is a rejection of my offer. So I no longer have any obligation. Hey, guys, make sure you're paying attention to this. No distractions. I see a lot of movements. No distractions. I'm telling you, this will be on the exam. And there's a lot of questions regarding contract law. All right? There's a lot of questions. There's 14 questions almost regarding contract law. And that's one of the places that you guys are failing at when I look at your reports. I'm letting you know. Pay attention to me. Okay? So, rejection. Very, very important. Okay? So, do you have to move forward with the no drapes? No, because your offer was rejected and vice versa. Now, what if you said the seller said $200,000, no drapes, and he said, you know what? I'm thinking. If that's the case, no drapes, I'll do 195, and I agree to the no drapes. What just happened? Do I have to accept? Does the seller have to accept this one right here because the seller made a counter? Do they have to accept this? No. So now the buyer rejected the seller's counter. And we can go back and forth, guys. This is what happens during attorney review most of the times. We go back and forth changing letters, changing numbers. It goes back and forth until we reach, again, meeting of the minds. Until this happens, meeting of the minds, until this happens, we go back and forth and nobody's obligated to move forward. Okay? Once both parties are in agreement, so seller will now go, you know what, 197, and that's it. That's my final. All right? And buyer will go like, hey, 197, we're good. I can buy drapes of $3,000, no problem. You guys understand? Once everybody agrees to all the terms, we're good to go. Until then, these are all rejections. And any party, very important, because there will be a question, what can a buyer do at this point? Any party at any point can just walk away. As long as there's a counter, there's a rejection, and my offer is no longer valid. Right here. Okay? The offer is void. Very important you guys understand this. Any questions? Any questions, guys? Nope. All right, cool. Contract preparation. Now, state laws define the extent to which real estate brokers and agents may legally prepare real estate contracts. Such laws referred to as Laura just countered 175 with drapes. You're a hard negotiator. These old bridge people. Anyway, Miguel says negotiation is realtor to realtor. Well, no. We're supposed to communicate any offers. We have to present all the offers before I move forward. We have to present all the offers to the seller and counter offers to the buyer. We are supposed to. I mean, we have to. So some realtors don't, but we have to. Now, if you bring me an offer, I present to the seller. Now, my job as a salesperson, we are real estate consultants. So my job is to advise the seller, my client, on, is this a good offer? Should we counter? Should we do this? Should we do that? And Mr. Seller, please understand that if you counter, we might lose it. So are you sure you want to change the terms of this offer? And the same thing when we get a counter. We go to the buyer and say, hey, Mr. Buyer or Mrs. Buyer, this is the counter, right? You can counter this and do that, but are you sure? So our job is always to make sure they understand that if they counter that offer, it might fall through just because of that change. It's not a matter of putting pressure, oh, my realtor forced me to get into the contract because he asked me, are you sure? Right? No. It's just, we're consultants, so I have to give you all the options and make sure you understand that any change could lead you to lose the deal altogether. You guys understand? So Miguel, our job is to speak to the client, understand the client's needs, and then we communicate that as a counter to the other realtor. So with our advice, they counter. We don't counter anything. The seller does, the buyer does. And once it's accepted to move forward, then attorneys handle that portion. In certain states. In other states, things are a little different. Robin says, so this falls on the real estate agent before it goes to the lender. Absolutely. So the first step is actually figuring out how much money you have. Right? We'll talk about it in a different chapter, but the first step is to get pre-approved. And the concept is very simple. Would you go to a restaurant, right? You go to a night out, you go to a restaurant without knowing how much money you got in your pocket? No. I don't care which restaurant it is. It could be, what, Jeffrey just said yes, I would. It could be even McDonald's, the dollar menu. I still have to verify that I have $1 plus tax in my pocket. But it doesn't matter what kind of restaurant it is. You should always know how much money you got. Okay? Does that make sense? So to buy a house, the concept is the same. They go to the loan officer first. So you advise them on going to loan officer first. You keep an open communication with the loan officer, obviously. And as soon as you get that pre-approval, hey, this is what they approved for. Now let's go shop. Let's go to those restaurants. Let's see the menu. Does that make sense? This is how much we can afford. $300,000. Let's look at houses at $300,000. From there on, the loan officer is not involved. It's us. We can negotiate up to that value, right? Now we found the house that they want. We start negotiations with the seller, and then once approved, now it goes to the attorneys and to the loan officer to get the right documents after that. Okay? So this is pretty much the process. And Erica just wrote, never take anyone to look at homes without a pre-approval. Again, find out if they have money to go eat. That's what it is. All right. So going back to this, some state laws allow us to prepare contracts. Other state laws do not allow us to prepare contracts. In any event, usually for commercial properties, we don't prepare contracts at all in any state. So some states, attorneys don't even get involved. So in Texas, for instance, and Arizona, and even Florida, you have to learn how to you have to learn contract law to the T. Okay, so you have to know everything in detail because you are the one drafting the whole contract. In state of New Jersey, as an example, we can prepare on 1 to 4 family residential homes. Above that, attorneys do it. We prepare the contract, we send it over to everybody to sign, and then attorneys take over. In the other states, attorney might not be involved at all. Okay? Should the realtor request to see? Absolutely. Verona, again, let's think about McDonald's. I gave you the example of McDonald's. When you go to McDonald's and you order something from the menu, is it a prepay or a post-pay? They go like, show me the money. If you have the money, I'll prepare the meal. If you don't have the money, sorry, come back later. And this is how you have to treat real estate. Show me the money, I'll show you houses. I won't show you houses without knowing what you can afford. And again, going back to that, it's a very, very simple thing. What if, put yourself in the buyer's shoes. What if the buyer, you're driving around, you show them 100 houses, right? And the buyer says, oh, this is the one I want. It's a $500,000 house. And then we start moving all the paperwork. It takes a month, 2 months, 3 months, whatever. A month later, you submitted all the paperwork to the lender. And lender says, you are approved for a $350,000 house. So your dreams are now shattered because you saw 100 houses. You're exhausted. I'm exhausted. And the house of your dreams, at least for that moment, it's unattainable. You can't reach it because you're not approved to buy. You don't have the cash, right? You don't have the financing. So yes, get the pre-approval before anything else. Show me the money. Estefani, how long for pre-approval? Depending on the lender, could be 24 hours. If it's a lender that's prepared, tell you, hey, I won't work with you unless you give me all the paperwork I need to verify, right? So the lenders you work with should have the same ethic as you do. So show me all the paperwork. I need your W-2s. I need your pay stubs. I need your banking statements. I need your IDs. I need to pull your credit, right? That could take time. But once I have everything in order, here's the same day, everything in order, could be 24 to 48 hours, you get your answer, the pre-approval. Does that make sense? But anyway, these are things for later on. All right, Estefani, here comes the other question for a friend. He's like, the family member realtor never explained this to me. Is it true that it's only valid for 30 days, 90 days? So it depends. It depends on the lender. They could be valid for 60 days. But on average, yeah, 90 days. Because that's the time it would take from finding a house to closing. So 2 to 3 months. Could it be extended? We'll talk about that later as well. But yes, well, the rate lock, and then you pay for rate lock extensions. All right? So, talked about contract preparation. Elena, 20% down is only if it's not your first time buying, or if you want to go conventional and you don't care about sponsored programs. But again, we have a whole financing chapter, so we'll get to that then, okay? The down payment is only once, regardless of being 3.5%, being 5%. It's a down payment is once. Yep. You can send extra money if you want, but down payment is once. All right, guys. Classification of contracts. It could be oral or written, expressed or implied, unilateral, bilateral, executed, or executory. Oral or written contract, guys, you already know. I already said earlier, we can have an oral agreement and it's still enforceable. We can have a written agreement, it's even more enforceable. So there's something called parole evidence rule that says that contracts in writing supersede oral contracts. Okay? There's expressed or implied. What is the difference between expressed or implied? Well, in expressed contract, I'm telling you what we're going to do, or I'm putting in writing what we're going to do. Implied contract is what we expect each other to do. Okay, so it's based on suggestions of an agreement. So implied contracts is based on actions and suggestions. Okay? Express contract, we manifestly stated and agreed to the terms. Okay? So, I'll give you an example. I told you guys when we started this on Monday, I said, guys, it's a 75-hour course. So I stated 75 hours, right? I said that it's for 4 weeks, Monday through Friday, from 5:30 to 9:30 p.m. I'm stating it. That's the expressed part of it. What is implied? It is implied that if I'm doing my part, you should be doing your part. Does that make sense? It's implied. For this contract to be valid, for you to be able to say, oh, Bruno, you never did anything for me. Well, show me that you worked for it. Right? And the people that are constantly sending me messages, right, constantly asking me questions, they know that I work for it. I will answer your questions, right? But if you don't, if you're not studying, if you're not showing me that you're there, it's tough for me to go and knock on your door and say, hey, do you have any questions? Can I sit down with you and help you? Right? It's tough for me to take that action. Does that make sense? So you need to reach me. It's implied that you're studying. It's implied that you're paying attention. It's implied you have no distractions, even though I'm expressing the whole time. But it's implied from the get-go. That's on you. It's implied. For me, I stated 75 hours I'm going to be here. At least 75 hours is mandatory that I'm here. And then I stated that beyond the 75 hours, beyond the class, I'm also available. I don't have to. I only have to be available from 5:30 to 9:30. Everything else is on you, but made myself available. What's implied? You guys understand the difference? Expressed or implied contracts? Expressed, we stated. Implied is what you should do or what I should do. We never told each other. It's expected of you. Okay? Then we have bilateral versus unilateral. Okay? So, first thing to know is the word lateral, side. Okay? So, side. If it's bilateral is two-sided, unilateral is one-sided agreement. So, bilateral versus two-sided agreement is how many of the parties have to comply with something in order to make it enforceable. In the bilateral agreement, both sides must take action. In the unilateral agreement, one side must take action in order for the other one to do their part. All right? So, it says right here, bilateral contract is one in which both parties promise to perform their respective parts in an agreement in exchange for performance by the other party. So if I put my property for sale and somebody puts an offer and says, hey, I want to buy your property. Once we go under contract, there are certain steps that I as a seller have to take and you have the buyer has to take, right? So you have to get pre-approved, you have to pull title, you have to do home inspections. On my end, I have to get a CO, for instance, certificate of occupancy. Right? On my end, I must make sure that all the mortgages and liens are paid off. That's my part. That's your part, right? So as the contract proceeds all the way to closing, there's steps that I have to do, steps you have to do, and we promise that we'll do it before we reach the end. So that's a bilateral agreement. A unilateral agreement, only one party promises to do something provided that the other party does something. So if you do this, then I'll do that. Okay, so if you do this, then I'll do that. That's pretty much what it is, right? So the latter party is not obligated to perform any act, but the promising party must fulfill the promise if the other party chooses to perform. So for instance, an option. Option is the rent to own or lease with option to buy, right? Lease with option to buy. So what we're saying here is, I'm going to rent your property for 2 years, and at the end of 2 years, I'm going to buy it from you. If I have the option to buy at the end of 2 years, you cannot sell to anybody else, right? But I have an option. That's why the word is an option. That means I can back out at any time. I don't have to buy, but I have the option to buy. So think about this as leasing a car. When you lease a car, you're going to lease the car for 3 years, as an example. At the end of 3 years, you have the option to either buy the car for an additional amount of money, or exchange car, or return the car and just walk away. Yes? All right, so option for houses is exactly the same thing. I'm going to rent the house for 2 or 3 years, right? And at the end of that period of time, we agreed already, at the end of the 2 or 3 years, I have the option to either buy, right, or walk away, or even renew the option if it's possible, okay? If I do exercise the option, if I do say, yes, I want to buy at the end of 3 years, now it becomes a bilateral agreement. So until we got to that point, it was unilateral. The seller could not sell, but the seller did not have to do anything until I decided to do it or not. So if you do this, then I'll do that, okay? And that's what it says here. The party offering the option, or the optionor, promises to sell the property. So the seller or landlord, temporary landlord, if the optionee, which is the buyer, decides to exercise that option. While the potential buyer does not have to buy, the owner or the seller must sell if the option is exercised. So again, think about this as similar to car lease, okay? So option is similar to a car lease. Think of it the same way. I'll rent, and after a period of time, I can either buy or I can walk away. It's an option. I don't have to buy. Okay? Any questions here? Laura wrote, option agreement is unilateral. Yes, until exercised. So until you move forward, it's an option. The moment you move forward and say, yes, I want to buy, I'm at the right time, I want to buy, then it becomes a bilateral agreement. Yep. Any questions? You know? I got some faces going on, so I want to make sure everybody understood it. I saw the finger. Right. What is okay. Actually, let me address Robin real quick. Who has the upper hand in the unilateral contract? Oh, the person with the option. See, when you go rent a car, lease the car, right? You don't have to buy the car, but you get to use the car, right? And then you have the upper hand because the dealer cannot sell to anybody else or rent to anybody else while you're there. So who has the upper hand? I do, the one with the option. Okay? So seller's trapped during the 2 years. And then once you exercise the option, that's it. So I have a controlling interest. Guys, when I started real estate, when I started investing in real estate almost 16 years ago. This is how I started making money, flipping lease options. Because I got the control of the property for less than $1,000, sometimes for $1. I got control of the property, right? And then I will rent it or flip the option to buy to somebody else. So who has the control? I do. Who has the upper hand? I do. The seller is stuck. So, not saying that it's stuck like in a bad way. It's just that, just like in a car lease, the dealer cannot sell your car while you have the rental agreement, because that's what a lease is. It's a rental agreement. Hey Stefani, what is express contract again? I was in the bathroom with Dory. Just keep swimming. Okay, so what is expressed is I'm telling you exactly. I said just keep swimming, and I get somebody on the screen. There you go. Express is when I tell you the full terms of the contract. This is what you're supposed to do. Okay, where implied is what this is what you should be doing. Good. Oh, executory versus executor contract. I'm going to start with the bottom one, and then we're going to go to the top one. Executory means pending. Executory means pending, a pending contract. So if I put an offer to buy your house, and you accept the offer, are we closing right now? No, we're not. When are we going to close? I already told you earlier they could take 2 to 3 months, right? So let's put 90 days. During the 90-day period, there are certain things I have to do, certain things you have to do. So during that period of time, this contract is pending, right? I'm buying something, but we're going to close later. So the contract is pending. Once we close, once we finish the whole thing, it becomes executed. It's all done. Yep, Laura. That's it. All right. So very simple. Executory, something is pending, so we still did not close. Executed, we finished, completed, done. Okay? It's as simple as that. Questions? Nope. Very simple, right? Contract termination. So we're going to talk about forms of contract termination. So termination of contract, also called cancellation of discharge, may occur of any of the following causes. Performance. Okay, so hopefully the reason why we terminate this contract is because we performed. We closed. Simple. We made money. The seller sold, the buyer bought, and we made money. Performance. Okay? Infeasibility. So you could terminate because it's not possible to perform. There are certain things that stop us from being able to move forward. Okay? Mutual agreement. Buyer and seller mutually agreed to walk away. We're talking about termination of contracts, how they could be canceled. Cooling period rescission. All right, so let me address this one real quick because I've had this, apparently it showed up in a couple of questions in the state exam, and usually in the previous version that I was using, we never talk about a cooling period. So rescission is the act of nullifying a contract. We got that. Cancellation, whatever. In many states, parties to certain contracts are allowed to a statutory amount of time after entering a contract or cooling off period to rescind the contract without cause. No reason need to be stated for the cancellation, and the canceling party incurs no liability for performance. So, I'll give you the example is, we're going to go over this one. But let's say you put an offer. In the state of New Jersey, you have to have the right to attorney review. The 3 business day attorney review could be the cooling off period. Why? Because while you're in the attorney review period, the 3 business days, you can just say, hey, not interested anymore, and walk away without any liability, without any penalties. So that's our cooling off cooling off period in New Jersey, is the fact that we put an offer and all of us need to cool off and make sure this is what we want. That's the attorney review cooling off period, and we can walk away without any liability. Okay, the example here says, consider the unsuspecting buyer of a lot in a resort development. Such buyers are often targets of hard sell tactics, which lead to a completed sales contract and a deposit, much like timeshares. Remember we talked about time scams, right? Same thing. So they have tactics where they push you through the timeshare, and you're not ready for that. So the statutory cooling off period gives the buyer an opportunity to reconsider the investment in the absence of that persistent salesperson. Okay, so in New Jersey, again, it's the 3 business days for local properties. If it's out-of-state properties, it's 7 business days. If it's planning new developments, it's 7 business days. We'll go over all this in the final week. But that's the cooling off, where we're not under pressure. We get to cool off and understand what really happened. Okay. Revocation is a cancellation of the contract for whatever reason, but mainly without consent of the other. So that's revocation. There's abandonment, when one of the parties failed to perform the contract. This situation might allow the other party to cancel. So if you didn't do your part, seller, I can walk away. Okay. Muslim is asking, so what does the exam ask regarding this? That's what they're going to ask. What is a cooling off period? And it gives you four answers. Or they give you a bunch of things like John purchased a property and from a persistent salesperson, and they're still in the cooling off period. What can John do? And then gives you 4 options. He may rescind the contract without any cause or explanation or whatever during the cooling off period. Okay, so it'll be something to that effect. All right, lapse of time. So lapse of time means the expiration time came. So like in the listing agreements, Erica says, wait. What do you want me to wait for? What was the answer? Your screen went black. That ain't my fault. I didn't make your screen go black. I already go to the replay. Here's the answer. During the cooling off period, you may rescind the contract without any cause or liability. Some of you don't know me. I see your faces like, what is he doing? I'm always messing with somebody, so I apologize for that, and I can't stop. I've tried over the years. It's bigger than me. I have to always give an answer. Yep. All right. Let's see. Lapse of time. So in the listing agreement, as it says here, in a listing agreement, as an example, let's say we listed for 6 months and the 6 month ends today, 9/21. If we did not renew as of tomorrow, the contract that we had to list the property and get compensated for it, right, has ended automatically. Okay, so lapse of time, it ended. Invalidity of contract, we already talked about that. If it's void because if it's illegal or whatever reason, the wrong type of coke, it's automatically voided, so nothing to be said. Breach of contract. There might be questions regarding breach of contracts. Let's go over these. A breach of contract is a failure to perform according to the terms of the agreement. It's also called default. A breach of contract gives damaged party the right to take legal action. Now, here, we're going to do this. Failure to perform. Without. So, Muslima, you have this in the book. Without legal excuse. Verona, I saw yours. I just want to make sure everybody writes this. So can the failure to perform without legal excuse, meaning you backed out of the deal without something solid. For instance, if I don't get approved for a mortgage, that's a legal excuse. I told you that this contract was based on my approval to get the mortgage. That was the condition. If I don't get approved for it, can I walk away? Absolutely, without consequences. You were aware that if I don't get approved, I don't pay. I don't pay, I don't buy. I got it. But that's a legal excuse. Me telling you that I'm not buying because I have a headache and I don't feel like buying anymore, it's not a legal excuse. You telling me that you don't want to sell anymore because you know, I thought about it. I was going to go down to Florida, but then I just decided to stay. Not a legal excuse. You guys understand? After the third business day, after that cooling off period, it becomes legally enforceable. Okay? It's final. So from that point on, unless you have a legal excuse, something solid, right? Then you cannot cancel the contract. So it becomes a breach of the contract. Again, Verona, did not forget yours. But the damaged party, whoever suffered, may elect the following legal remedies: rescission, which is cancellation; forfeiture, which is I give up; or sue for damages, or even sue for specific performance. Under specific performance, the words specific performance, that means to complete the contract or conclude the contract. Okay? So as an example, to buy or sell. So what is specific performance? I'm going to sue you to sell your property even if you want to back out. You cannot just back out. You promised 2 months ago, you promised that you were going to sell to me. So I'm going to sue you for specific performance of the terms of the contract. Okay? Or a buyer. Buyer that says, I'm not going to buy anymore. The seller can sue the buyer to specific performance, to force to buy, conclude the terms of the contract. Okay? Every time you see specific performance, that's what it is. All right, Muslima had a question. Can the buyer cancel before a lapse of time expires? So when we talked about the lapse of time, I was talking about listing specifically. Listing is with the seller. The seller can cancel. The buyer, after the third business day in New Jersey and some other states is very similar, can... Muslima just wrote, not my question. Did you ask a question? So Verona says, okay. So what was I saying? So for the contract to purchase, the buyer cannot back out after the third business day. He has to move forward unless there's a legal excuse, like I said. Miguel, does cancellation need to be written, or is verbal suffice to back out of a deal? It depends on what it is. Okay, but if it's during the cooling off period, I don't have to give you any reason other than or anything in writing. I just say, I'm done, I'm out. All right. Beyond that, if you're going to have a legal excuse, then obviously you should do all the efforts possible to have it in writing. Otherwise, you could still be liable for lawsuits. Okay. Okay, rescission is canceling. We already said that. Forfeiture means that you're just giving up. Suit for damages. So suit for damages is I'm asking the court to force you to compensate me for the time lost, for the money's lost. So I took money. Verona, yeah, that's what I said. They can get out of the listing before it expires. Yep. So I took money from my 401k to be the down payment to buy your house, right? So now I have to pay penalties. Now I have to pay taxes. Now I have to do this. Now I have to do that. And you decide not to sell, yeah, I'm going to sue you for damages. I'm going to sue you for every penny that I took out of the 401k that I have to pay back with interest and penalties and whatever. I'm going to sue you for all the time that I lost looking at your house when I could have been looking at another. So that's a lawsuit for damages. Now, what sometimes happens is you settle for something, liquidated damages. And usually liquidated damages come out of keeping, as an example, keeping the good faith deposit or the earnest money deposit, whatever you want to call it. Okay? Can I address good faith deposit? Yeah, we're going to go over that in a little bit. So the liquidated damages will be, hey, I'm not going to sue you anymore. I'm going to settle for whatever we put as a good faith deposit or earnest money deposit. Or if I don't want that, if I want more money, then I go in court after more money. Okay, hold on. Muslim is asking, I've heard where sellers try to play games to cause the buyer to back out when the house appraised for more than the listing price. All the time. Yep, all the time. Good luck with that. Not to my buyers. I appreciate the extra equity. We made an agreement at 300. It's worth 320. Thank you very much. But yeah, they try to do everything possible to back out. No, I'm going to sue you. Well, not me. My client is going to sue you for specific performance. They're buying. And Robin, I'll address that in a second. Yep. All right, so we already talked about that. Suit for specific performance. All right, and we're done with the chapter. Now, as far as the good faith deposit, I thought there was a little bit more. Okay. As far as the good faith deposit, so the earnest money or good faith deposit, guys, we'll talk about that definitely when we get to the real estate side of it. This is just law in general. But the good faith deposit, as it says, is good faith. So it's not mandatory, but it's highly suggested that you put money into a contract, right? Because you're trying to show the seller that you have intentions of really buying their house. You're not just putting $1,000 here, $1,000 there, and everywhere, right? Okay, and I just did old McDonald's with a good faith deposit. So what's happening is you're showing good faith that you will follow the terms of the contract. That's what it is. If you breach the contract, as we were just talking about, then the seller has the option, well, I appreciate your $1,000, I'm going to keep them. Or 5,000 or 10,000, whatever we collected before closing, I'm going to keep it as a settlement, as liquidated damages. So the good faith deposit is treated like a security deposit on the rental. If you don't follow through with the terms, I keep the money as a landlord, in this case, as the seller. Okay, so that's what the good faith deposit is for. Okay, we'll have math towards the good faith deposit, and we'll have that in the I think it's 2 chapters, chapter 12 or chapter 13. We're going to go back to contracts anyway. All right? Guys, do you have any questions, anything you'd like to address? We still got 20 minutes. We've been doing good. Laura, any questions? If you're still watching, let me know. Are we having a practice test before the real one? Yeah. on the website, on the student portal, there's a link for practice tests. As far as the real one, yeah, you're going to have one. And you're going to pass it, and then you're going to move forwards to the other real one, which is the state. But if you go to the student portal, which I don't recommend yet, even though I know some people have already been trying. Oops, sorry. But if you go to the student portal, you go to course resources, and it says right here, if you completed 90% of the course, test yourself. So in the final week, that's when you go in and test yourself. Okay? And that will help you have an understanding of where you are. By the way, I'm updating both the fingerprinting and the scheduling of the exam because both of these changed. So I'm going to update this on how to links and everything on how to schedule your exam. Like I said, right in the beginning of the class, there was less for people, so now I address it again. I already created a video on how to schedule your school exam now. Okay? And the great news, as some of you were very happy about, is that now you can do the state exam from home. Okay, so I will, you have the option, you can do both. If you want to go to the testing center, the difference is you're going to have to wait until whatever availability you have, but you are able to do it from home now. Okay, so two options are there. Again, I recorded, I will have the video out till the end of the week, hopefully. And on Wednesday, I'm going to take the exam myself to see how the remote thing is working. All right, so that's a lot of cool stuff right there for me. Thank you, Laura. I appreciate that. We have here. How long do they give you to complete the test? So I do the same as a state. You have up to 4 hours. We try to mimic as much of the state exam as possible, so you guys don't feel that impact of being in class and then going to state. The only difference is right now we're doing everything virtual. They finally approved virtual. If it was in person, here you're not in the cubicle, while there in the state exam, you are in a cubicle with a camera right on top of you. So that's pretty much the only difference. My exam has the same options. You can bookmark and move forward. You have the same 4 hours, one attempt, one question per page. Pretty much everything the same as a state, but up to 4 hours. If you can do it in 1 hour or 2 hours and want to finish, conclude, you can. You want to take your whole 4 hours, something is wrong. I'll tell you right now, if you take more than 2.5 hours, it becomes a problem, because that means that you are questioning yourself and you're changing answers. That's most likely what's happening there. So less than 1 hour is a problem. You went too fast. You could pass. Don't get me wrong. You could pass. Just the same way that if you want to take the whole 4 hours, you could pass. What I'm saying is that the optimal time is anywhere between 1 hour and 2.5 hours. No less than that, no more than that. I already know, because I see here, I've had students, while I'm looking at you guys, and your exam here on my screen, and you got a passing score, and then all of a sudden, it starts slowly going down. I'm like, no, please stop. And I can't wave at you. I can't talk to you. And I wish I had like a buzzer and say, hey, stop touching the answers. But more than 2.5 hours, you are most likely changing answers. Okay? What I'm trying to say is don't change answers, period. How many questions? You have up to, you have 110 questions. Laura, I'm glad I got your attention. Hold on for a second. So you have 110 questions. They actually give you 120 apparently. I never had 120, but the number of the questions that count is 110. When you get your score report, if for any reason you fail, it shows 110 questions, even though you answered 120. The passing grade. So we're talking about New Jersey, okay? So the passing grade is 77 correct answers, which is 70% passing grade, okay? Go back to my question. How long do you have after you take the school exam to take the state exam? You have up to 1 year from completing my course. I do have to say that as soon as you pass mine, okay, as soon as you pass mine, take the state. Do not even breathe. Go take the state as soon as possible because everything is fresh. Mine, you have to pass with a 75% score. Theirs, you have to pass with a 70% score. Mine is tougher. Yours is easier, right? At least in general, that's the answers that I get from most of the students that go to the state, right? So I try to make it tougher on you guys so when you get there, it's a piece of cake. But the longer it takes for you to go to the state, the worse it is. I'm telling you right now. All right, Laura, yes, you could take the exam from home now. You can reschedule. You can. Oh, cool. You can reschedule if you want. You can contact PSI. You can do it from home if you want. The thing is, one of the things they changed now is for if you choose online, and I'm gonna have that highlighted in the video for scheduling the exam. If you choose the online version of the exam, the final exam, and for any reason you need to change the date, you need to reschedule, you cannot do it within 48 hours of the scheduled exam. If it's the in person, you cannot do it within 24 hours. What does that mean? It means that, for instance, I have it scheduled for Wednesday. It's less than 48 hours away. Can I cancel my online exam? No longer. Okay, so if I miss that one, I'm going to have to pay again $47. Okay, so make sure you guys don't miss anything. Verona, do you have opportunity to take yours again if you don't pass? Yeah, you can take as many times as you can within a year. What might happen is that they tell you after like the third time, true stories, after the third time, they might tell you, come back in a month. So every 24 hours, you can take another exam. Online, I think it might be the same scenario as a cancellation, maybe every 48 hours. But you can take as many as you can until they tell you, okay, you've been trying too many times, come back in a month. Like study. That's pretty much what it is. Study. We don't want your money. Go study. Okay? If you're talking about the school exam, you paid for 2 tries. So you paid for 2 school exams. But you don't need that. You're going to pass the first time, right? That's it. Robin is asking, do you have a recommendation, in person or online? Let me have a feel for it on Wednesday. That's why I'm going through the exam myself. Let me have a feel for the exam, and I will let you know if it's much different than my exam, like the whole scenario of proctoring, of people overseeing you. If it is the same thing, then I can tell you some people are good with online, some people are not. If it's not the same thing, then I'll tell you in person. If I don't feel it's good enough for you guys, I'll tell you to go in person. Okay? Yvette, if you fail the school exam after 2 tries, I'm sorry, I can't read properly. What? If you what? 2 tries? What's wrong with you? You're gonna pass the first one. What do you mean? Were you already setting yourself up for failure? Okay. But if you do fail, the registration and our school website does say that we charge $25 for each exam beyond that. The problem is that both Pedro and I, so my business partner and I, we have a soft spot and we're horrible at charging. So we might give you a 3rd try. We'll see. It all depends. I mean, there's something called bribery. So we will do it like an exchange. Like I'll give you an extra exam. You can what's that face for? I mean, okay, we're still on the live. Just kidding. There's no bribery for results. There's consideration. Not for results, because look, it doesn't help, guys. I'll be 100% honest. Even if I gave you the answers for my school exam, how's that going to help you in the state? Right? So I like to joke a lot, but I know schools that are giving results, and like the answers. And you get to the state, it doesn't help you. You know, I'm not the best school out there, but I can tell you that right now my average of what I get from the state exam, my average is above the state average. So I'm about 13% pass rate above the average of the state. So 13% above, for me, it's a lot. Already says a lot. Okay? It's very, very important. Miguel is asking, the school testing, is that only during daytime? No, because we have nighttime classes. I also have nighttime exams. So yours will be the Thursday after you complete the course. So we finish in 3 weeks, right? Yeah, we finish in 3 weeks. The week after, on the Thursday at 5:30 p.m. is going to be your school exam. That's it. Yvette, sure, 100%. Not even a question. My favorite. Still don't get the results, but I'll be very happy. Saying. Any other questions, guys? No questions? All right. Aurelius is already saying goodnight. All right, Aurelius. All right, guys. So if there's no questions, I hope you guys have an amazing evening. Make sure you guys go over the Quizlets. Take advantage of that. I did update for you guys. Bring questions for tomorrow. Whatever you guys need, I'm here for you. Send me messages on WhatsApp or share in the WhatsApp group any questions you have while studying. And people there are very helpful. So take advantage of that. Thank you, Stephanie. All right, guys. Good night.